You know, before we commence, may I provide you just a book we just provided as council? May I approach? Thank you, Your Honor.
Thank you.
I apologize. Thank you, Mr. Vice.
All right. Defense, go ahead.
Good morning, Judge. First off, wanted to address a issue. We have the microphone again that's at council table. However, I've been informed by admin services that upon you giving the nod, he can just disconnect it right now.
Is it? There's just a push button there that they would have to push.
To mute the mic, yes, they would have to push and hold.
Okay. You can. Let's go ahead for now, just to kill it. We're in a small enough courtroom that I don't think it'll be an issue. Everybody should be able to hear, and the sound should be okay.
Okay. Do you want me to? Okay.
Yeah.
I'd have to get under the bench and unplug it.
Okay. If you need to, let's go ahead. Okay, we're all set? All right, let's get on with the motion.
Fortunately, Judge, may I check out in the hallway? We're looking for a witness who has yet to appear that we've arranged with his counsel to be here. Apparently it's not. Judge, contrary to our expectations, I had spoken with a gentleman by the name, an attorney, Bill McClellan, who represents Joe Jordan. He assured me that he would bring his client to court, and of course he is not present at this time. He may have, since we switched courtrooms.
Well, why don't you go ahead with the motion, and if he shows up, great. If not, that's that.
Okay. First, Judge, I think what I'd like to start off with is advising the court that we have two distinct yet equally important arguments as it relates to our motion. First off, the documents requested are subject to a subpoena duplice tecum for the specific EquiSearch documents that we're seeking. Three main reasons why they are is one, EquiSearch conducted business in Florida. In fact, they went so far as to open a Orlando chapter. Two, as argued previously before the court and supplied in our memoranda, we believe and we believe we've shown that they were clearly acting as agents of the state. And three, the documents are actually here in Florida. Now, the last time we were present before Your Honor, EquiSearch made several representations to the court, namely and specifically that there was no one who searched at the area where Kaylee Marie Anthony's remains were found, and B, that there were only 32 searchers that were not that were actually present there in that area off of Suburban Drive. Upon investigating this a bit further, we have found four people, specifically Joe Jordan, Laura Buchanan, Danny Iverson, and an unknown Panama City police officer who apparently later on in the discovery we've realized that through a statement by Corporal Edwards that they in fact know who this Panama City police officer is, or believed to be, or believed to know. Taking it a step further, I looked up, I went online, Judge, and I looked at the Orlando Sentinel, where oftentimes while this was going on, there were numerous media taking photographs, interviewing people from EquiSearch, and videotaping their searches. And in the process of doing that, no, this is the court exhibit. No, we don't have to.
Go ahead.
Can we see?
Sure. Apologize.
Sorry. Council just on that?
Yes. Yes. This is my stash from the center. Oh,
There's more.
Judge, I can go while they are still looking at photographs. As it turns out, there are photographs, and the court can weigh its own credibility as to the source of these photographs. But Judge, I specifically went online, and where these photographs were printed out, some of them were off of Suburban Drive, which they labeled.
I'm going to
Suburban
object,
Way.
I'm going to object, Your Honor. This is it's putting into evidence his own observations or purported observations. There's no proper predicate to any of this.
You can argue when you come up. I understand that fact. You can simply tell
Thank
me
you.
your version of this when you go ahead.
And Judge, I would submit to, for photograph identification O, there's a photograph of Danny Iverson with his cadaver dog in front of the lead detectives, Yuri Melich and Sergeant Allen and some other unidentified people. I have approximately 5 or 6 photographs identifying other individuals, which, for argument's sake, since none of these names have been made public, I'll keep them to myself, but or I can submit it to the court and the court can see their names. But these people were also not. Here's a woman who was off Suburban Drive who's now on the list of 32 people.
What makes you think she was from Texas Equistration?
Well, these were all under an encaptioned area that specifically said dealing with searchers from Texas EquiSearch. Here are 2 other individuals who are now on the list that were also photographed searching in that area off Suburban Drive. And again, several other photos, Judge. I can submit them for viewing. Some of these searches, if you look to the back, they don't have anything to do with Suburban Drive. I just took them and may refer to them in my later argument. Now, our point, obviously I think the court has heard arguments previously in reference to the materiality of finding out who these people are. And obviously, Judge, it just takes one person to believe that that the remains of Kaylee Marie Anthony were placed there after Casey Anthony was locked up in jail to reach a reasonable doubt, which of course would require Miss Anthony's acquittal. Now, the pleadings that were referenced by exhibit. This is a defense composite F.
Do you have a copy of me, please?
That's the exhibit.
Do you have a copy?
No, I don't.
I can abbreviate. May I ask counsel a question?
Now, I'd like to show, and I'll be submitting the composite later. I'm going to refer, Your Honor, to 895. The signature on the bottom is what Texas. I think, Your Honor, clearly see that you can't make, especially if you don't know the name of the person you're looking for. The second, I can take a look and see if I find Joe Jordan. It's not possible. I don't know if you want to. By the photocopy. But what's critical here is that there's no contact information. Becomes a search, fills out these were 4,000 searches. Do this, conduct the search. There are numerous documents. Now, that was turned over to us. If you look at the specific exhibit, very difficult to look at the context Her name was Laura Buchanan. The pleadings that say Miss Buchanan was initially searching in a then moved over to the Suburban Drive area. As well as Mr. Jordan, that quite frankly aren't in that. Mr. Jordan's own statements, which which the state took in this case. Mr. Jordan claims that he searched an area, Wooded Gate area, that a cooler and several other items. This area was then searched and apparently there was some discussion in the woods. As it turns out, Judge, that Mr. Jordan, I'm going to show you identification A. Exhibit A, Mr. Jordan sent an email to both John Allen and Yuri Melich, where he states that he was a team leader in terms of evidentiary value. He stated that he also had 2 qualified dogs in that location that were knee-deep in water. And during the search, there was another male neighbor. The area is searched multiple times before a body is sometimes found. I believe the remains were moved detectives 13th of December 2008. We just received this email 2 weeks ago. I'll address later in the argument. We find this very concerning. The body after the defense found Mr. Jordan by way of Laura Buchanan. This is in no uncertain terms, Judge, a bombshell. We feel that obviously this should have been turned over much earlier than 15 months, especially since we've had it for 15 months.
Your Honor, I'm going to object to the relevance of this today.
I'm going to sustain the objection.
Now, subsequent to us finding Mr. Jordan, then actually the Mr. Jordan attorney's office to discuss with Mr. and all 3 lead detectives in the case. Judge, and I do think this is a serious discovery issue. The state is required to turn over to the defense anyone either way, Judge, these documents are critical. Here you have a major issue where we've been able to uncover a specific individual who also references two other individuals, both of them cadaver dog handlers, and one of them a police officer, that searched right at the area where the remains were found, or very close to it. And this information was never turned over to the defense. You've got clearly an email here that should have been turned over a year and a half ago. And you've got the intentional omission of Mr. Miller from being on the state's witness list. See, we've been after these documents, we've been jumping through these hoops for about a year and a half now, Judge. We've asked for these, we've come to the court on 3 occasions. And now, the more we investigate the matter, the more we find out specifically that something's not right here. There are people there who are off of this, who are not on this list of 32 people as represented by EquiSearch. And we can't allow specifically a third party to determine what is or what is not relevant to a defense of a capital case. What the court has is the court is allowing Mr. Nijam to determine what's relevant to the defense. He in turn has waived, in our opinion, any privacy issues, because he himself has admitted that he's allowed Brad Conway, the attorney for the Anthonys, to view him. Where's the privacy issue then? And then, of course, through our supplemental pleadings, Your Honor can see he's also allowed the media access to him. Now, none of these names have been made public by way of discovery or a public records document or a public records request in any way, shape, or form. Every single name in this list has been kept private by the defense. The second was turned over to us. And we just keep finding other people that aren't on this list. I think the court, when it had its ruling and when it outlined its order, it never anticipated, A, that there would be more people, B, that it would relate to such a critical issue, a very critical issue, where clearly there are credible people there at that location searching. And in addition to that, other individuals seeing these names, and the defense not being able to have access to it. I think that's a clear violation of Miss Anthony's constitutional rights to be able to confront her accusers and cross-examine them appropriately, to investigate our case. And this is a capital case. It doesn't. The stakes don't get any higher than what we're actually involved in, Judge. And to allow this to continue, I think you would be cutting us off at the knees and not allowing us to investigate our case, where clearly there is reasonable justification to allow us to continue to search out, to talk to as many people who searched in that area or other areas that may have information related to that area by way of EquiSearch meetings where they discuss their findings, briefings, things like that. It's just gotten to the point where it's gamesmanship. And I think it should stop. Mr. Miller should have been listed on the state's witness list. Why is he not? Why are they traveling all the way to Texas to speak to this gentleman? He's flying back over here having meetings with detectives.
Why does the state have to put someone on their witness list that you want on their witness list?
Well, Judge, they should be able to put someone on the list who has information. That's their obligation.
All the witness list is who they intend to call.
Not necessarily. It's who they intend on calling and who may have relevant information. Clearly, Mr. Miller has relevant information. He's actually the only private citizen who they've allowed past the crime scene tape into the actual crime scene.
I don't know that. I understand your point, discovery versus the witness list. I think they're not one and the same. But anyway, continue on, and then we'll get over to Mr. Nijam.
Judge, in addition to, and I'll read, and I won't go back onto to the discovery issue, because I clearly do think that this is an issue that the court should be involved in. I think if the court looks at the document submitted in Exhibit F, the composite. I want to, and I'd like to direct the court's attention to a specific map. I can have your copy, Judge. I think I can find it.
We agreed to.
Unfortunately, the court's copy is a pretty bad one. That is an aerial map of Suburban Drive in the area where Kaylee Marie Anthony's remains were found. And if you see on the top left-hand corner, again, it's cut off by the photocopies. It says baby blanket and a line drawn to a specific area. That specific area is very close to the privacy fence which Kaylee's remains were ultimately found. Again, without having spoken to Mr. Jordan, we never would have been able to identify that that is specifically what that is. It is critical. It's critical to the defense to be able to get a hold of these documents, to be able to see if there's any other bombshells out there that specifically relate to EcuSearch volunteers searching an area and not finding Kaylee's remains. And especially since Miss Anthony was incarcerated and unable to be at that location in any way, shape, or form.
Thank you, sir.
May it please the court?
Yes, sir.
Thank you. Your Honor, I've provided the court and counsel a packet. I'll take you through it. I think it might help identify the issues and address them appropriately. The first attachment, Your Honor, is entitled Order on Defendant's Motion to Certify Timothy Miller as a Material Witness et al. You'll note in there, Your Honor, that I agreed to present Timothy Miller as a representative of Texas EcuSearch for depositions. And so that His Honor has, like all these other matters, has previously addressed that. We thought it was appropriate to have Mr. Miller here. So rather than getting to the issue of whether there was a technical material witness or not, I, as his counsel and as the agency, as the Texas EcuSearch counsel, agreed to him. They simply never bothered scheduling him for a deposition. He's been available throughout since His Honor entered this order on August 27th. And there it states it. And if they've not bothered since August coming to take Mr. Miller's deposition, I'm baffled as to how they could be claiming now that he's not available. His Honor has appropriately addressed the issue. Whether it's not my issue to put Mr. Miller on a witness list or not, that'll be between the defense and the state. All that I know is that I agreed to surrender him, or to have him here rather, so that he could in fact be depositioned. And since August, nobody's ever requested or required or made a phone call, letter, subpoena, or otherwise to have that done. So how that argument can be heard or even made as it relates to having Tim Miller, they need him so bad, he's here. Where have they been? I'm baffled that they could even come forward in good faith with such a suggestion. Additionally, Your Honor, if you'll know, on August 21st is when we had the hearing. On August 27th, His Honor entered an order indicating multiple things. And in some of those matters had His Honor ruled on were that we would provide the list of 32 people who we had identified as being in the relative immediate area where Kaylee was found. voluntarily to the defense. My office reviewed all those documents that we had. The state attorney's office reviewed all the documents, and out of courtesy for Mr. and Mrs. Anthony, George and Cindy Anthony, I allowed their attorney as the first person to ever review them. I thought out of respect that it would be appropriate to allow him, so that there were some questions in the media about the granddaughter and where she was, and I had Brad come in and spend days going through the documents. The only thing I asked of him is not to take any pictures or to write anything down. Any document that he saw that he deemed to be relevant, that he thought was in the immediate area of where Kaylee was found, he would tab, and we would have those identified. So he spent endless hours going through these. Every single one he tabbed was released. The same overture was made to Mr. Baez. As it relates to when we were in court, we said, come through and look at them. But because of the intense media scrutiny and attention this case has had, anybody and everybody shows up on the internet. And there were constant and repeated requests that were made to me, to various members, of saying, we don't want all of our personal information made public to the world. The defense's motion inappropriately states that these phone numbers can be picked up at any yellow page. That's not true. The reform indicates cell phone numbers. Those are not picked up in any yellow page. More importantly, these people did not want their identities put out there for the world. There's been threats in this case to people throughout, lawyers and others, as it relates to overtures made by the constant barrage of bloggers and others in this case. So there is a privacy concern. I don't even respectfully know why we're discussing this again. His Honor heard all this before. There's nothing new that they brought up, and there's no basis under the law that I'm aware of to allow this motion to be reheard again, which was heard in the first place. Significantly, though, with the first contact we had with the defendant's attorney after the hearing on August 21st was on September 18th. We got contacted by them indicating that they were desirous of coming by and inspecting the 4,000 approximate documents that we had in our office so they could comply with the court's order. We then heard that, so my office said, of course, give us a date, we'll accommodate them. We heard from them again on September 22nd, and we were told that they were not coming by the office, but instead they were sending a company called the Presentation Group. The Presentation Group is a copying company, and they were going to come by and copy all the 4,000 names and all the inclusive documents. We, of course, said, no, that's contrary to the court's order. You all are welcome to come by and review the documents, but you're not allowed to violate the court order, which is what their request was, and come by and do a wholesale copying of all the documents. They then understood we were not playing. We said, come on by, look at them, follow the court's order, but you're not just getting a Presentation Group, this company, to come by and Xerox everything. We then heard back from them about a week plus later, or a week later, I should say. And we got a call to our office saying that they were not coming by, and just to fax them the documents concerning the 32 or so searchers. We were not comfortable with that. For a whole host of reasons, we wanted to make sure that the integrity of these documents was maintained. So we voluntarily got them all copied and had them hand-delivered to Mr. Baez's office, counsel for Casey Anthony, so that they would have them all. And thereafter, Your Honor, those documents have sat all these many months with no request, no demand, no letter, no phone call, no email or otherwise to come back or to come in the first place and to review, inspect, identify them or anything. And how they can jump to this ridiculous conclusion that there's bombshells when they haven't even taken a moment, I mean not even a 5-minute inquiry to inspect the 4,000 documents, if they're all that important, is beyond me. They then claim in their motion, on page 5 in their response, that place, I'm quoting specifically, this is the defendant's motion, they placed, in the burden part, no, excuse me, in the memo part, they placed a burden upon the defense to review documents at the Office for Counsel Attest and identify further documents for in-camera review. So they claim it placed a burden for them to come to my office. They also say that there were several searchers that they identified, but they only listed Joe Jordan and Laura Buchanan identified by Mr. Byans. But the significance, Your Honor, they go, it's a heavy burden on the defense to come to my office. My office is a 10-minute walk and a 2-minute drive from this courthouse. If they've got time to do TV interviews and drive to TV stations, I think they should have the time to come to my office and review the 4,000 documents that they're jumping up and down they haven't had access to because they haven't made the time to come over. It is beyond me. It's incredulous to suggest that there's just bombshells and that there's this things have been hidden from them when they're just still sitting in my office. Come by after court.
Okay.
Pay a visit.
Talk to the court.
I apologize, Your Honor.
That's all right.
Now, additionally, Your Honor, their motion properly states, it's the first thing that it states correctly that I've come across, that Joe Jordan conducted a search on 9/1. If His Honor looks at the document on 9/1 that was presented by them, it was the date. So they, in fact, had Joe Jordan's document with Joe Jordan's name in the top left-hand side. Now, as far as the name being partially cut off or not, I can't answer that, except that they provided to the court copies made by them. So whether they cut it off when they made a copy for the court or otherwise, I don't know. All that I know is you can ascertain Joe Jordan's name. If they come by our office and looked at him, they would have seen the actual document. They opted not to. But it was still ascertainable. So they've had all the information. And I'll point out something else, Your Honor, which they conveniently left out. If you look at the document of Joe Jordan, which is identified in the back of my packet, sir, it says Joe Jordan form. It's the fifth one from the back. There's listed 10 personnel assigned. So these were all the people that were on the various search teams with any of the people. And some of them have their phone numbers. We thought it was appropriate to provide everything in toto. So we did. And everything on there, they could have contacted all these people and assessed who was in the immediate area and who wasn't. So in fact, it's actually more than 32 people. It's all the people that were assigned to the team leaders who were involved in the various searches, and I broke it down. Now, I would also state, did His Honor follow my logic on that, or where I was going with that? Very good. Also, the same thing as to Laura Buchanan. Interesting to note, Your Honor, and if you go to our package, you've got a statement, and I'll call it a statement because it's not sworn to, as to Laura Buchanan. It's the last one in the back, Your Honor. Second to the last one. You'll see, well, first of all, the second last one is Laura Buchanan. And there you will see, Your Honor, on the top right-hand side, it says Blanchard. Blanchard Park was not the immediate area where Kaylee was found. So, of course, Laura Buchanan's document was not part of the 32 because the document she filled out said Blanchard. It was no, and you'll see all the attendant maps around there. Now, Laura Blanchard, in her subsequent statement, and again, it's a statement, Your Honor, it's not sworn to, says that there was a breakaway, and several of them went off on their own, and they went in what she believes was the area of where Kaylee was found. It's in my package there, sir, under, it says, I think it's about the fifth one down.
What's the title?
Yes, sir. It would say Laura Buchanan. Looking for it. I went a little out of order in my argument, so I'm just trying to find it for you. I apologize.
Well, I see her tab. Is that what you're referring to?
Yes, sir. There would be one there for her. And she fills out a statement. It was also attached, I believe, to the defense's motion. But basically, it claims that she changed her. Here we go. It's under there. It's under, Your Honor, it's under Exhibit A. It would be under. It says Exhibit B, Statement of Laura Buchanan. I'll read it for the record. My name is Laura Buchanan. I currently live in Mendham, New Jersey. 2, on September 3 of 08, I was a volunteer for Texas EquiSearch. September 3 of 08, which is, if you look at the date of her Texas EquiSearch search form, that was the date on there, the September 3rd. I was assigned to Suburban Street in Orlando and searched the area where Caylee Anthony was found. We were not officially assigned to search that area. We went on our own. And on the top of her form, dated September 3, she says, Blanchard. So there's no way that anybody could ascertain that whatsoever. Now, if they had simply come by the office and looked at the documents and they thought there was anything there that would have in some way, shape, or form suggested otherwise, they were, of course, welcome to, as they still are. But the document that we've attached showing Laura Buchanan, they submitted, and we attached as well, there's no relevancy to that as it relates to that. And then her own statement says they went off on their own. So people who go off on their own, and they're doing it independent of Texas EquiSearch, how can Texas EquiSearch have a burden greater than or no more than they knew? They provided what they had and what they knew. Now, if you'll give me a moment, Your Honor. Please. I think that addresses all the issues. I would state, though, Your Honor, that we remain available, the documents remain available, that there is no issue. We have, in fact, because we believe that the court, we had an obligation, an ongoing obligation with the court. When additional documents were located, we put everybody on notice, and those remain in my office as well. There was a handful more that were found. Please understand, Your Honor, this is a charity that is very, very low on funds, relying on public donations. And to force us, that's why we made a request for sanctions to be imposed as it relates to attorney's fees and whatever costs in here. And I believe that 2 different areas permit it. And Rule 3220 allows for a sanction provision. N3. Oh, I need to make one other point, Your Honor. I apologize. Counsel for defendant commented about information being disclosed to a news reporter, Mr. Longo with Channel 13. So His Honor knows the facts. What happened, and Mr. Baez, on behalf of his client, was notified by Mr. Longo as well as to this. They were doing a story on the case. I said they cannot see any of the 4,000 searchers, and they did not. They came in and they saw where our matter of public record had been released, the 32. But I even went a step further. I said they can't videotape them, they can't copy them, they can't report as to any people's names, addresses, otherwise, even though that's already a public document. I said as to the 4,000 people, which remained 15 miles away, they couldn't look at them, view them, or otherwise. So all they did is they wanted to look at what was contained as far as general information, name, date, serial number, not the actual content. And I would not even permit them to put the content. So to suggest that we opened up the door.
You're saying there was no waiver on your part?
No, there was. Well, all we showed them was, that's correct. All we showed them was the 32 that were already public record. We still went a step farther. So if you want to go disclose those people, go do go find them yourself, go to the courthouse, or get them otherwise. We're not going to give them to you to release. We never let them look at any of the other 4,000 people. And the reason for the sanctions, Your Honor, is I believe the motion by the defense is in very, very bad faith. As soon as this motion was received, rather than jumping to any conclusions, I contacted Mr. Longo. I said, did I show you anything? Did I open up the door in any way, shape, or form? Did I show you any of those 4,000 people? He goes, absolutely not. In fact, you refused to let me witness anything. I said, would you be kind enough to contact Mr. Baez and let him know that his motion is not, that what he stated on the motion is incorrect and improper, and if he wants to withdraw it, we'll just proceed without any further action? Mr. Longo got back with me and said, Mr. Baez said he's still proceeding with the matter. Even though Mr. Baez was given the facts, and now we find ourselves before His Honor wasting the court's time, wasting the taxpayers' money for something that has been addressed and they were put on notice. This kind of stuff shouldn't be permitted. There's no new information that's been brought before the court, either because of laziness or sloppiness. This information hasn't been tracked down. All these protestations are being heard that they don't have access to the documents. They have. They just haven't taken the few hours it takes to come out and do it. And they're right. It is a capital murder case. And a capital murder case demands a lot more than not coming by my office and reviewing these documents if they're so relevant. Thank you, Your Honor.
Response, Mr. Bias?
Yes, Judge. I'm going to try and address the points made by my colleague in the order that he went. Starting off with the deposition of Mr. Miller. The reason it hasn't been set, Judge, is we don't have all the information for a proper investigation to inquire appropriately with Mr. Miller. We're not going there to ask him about certain documents that we don't have in our possession. I think it would be pretty foolish to go in and take someone's deposition without having all the proper information of which to base your inquiries on. And I don't know any attorney worth his salt that would conduct a deposition in that manner. So I think that argument clearly falls on its face. As far as nothing has changed, I would beg to differ. I think there's been some significant changes. Finding Mr. Jordan, finding Ms. Buchanan, finding out that there's a police officer from Panama City who is a cadaver dog handler, finding another cadaver dog handler that was there that wasn't disclosed is very important information. It's critical to the defense, and I think if Your Honor looks at the map that I provided for the court, you can see it is right in the vicinity where Kaylee's remains were found. So to say nothing has changed, I think that is a gross understatement and not a very good argument. Now, as far as inspecting the documents are concerned, this is an area I really didn't want to go into, but I somewhat feel compelled to. If Your Honor looks at these documents, they are in no particular order, and they are one page doesn't relate to another. Okay, completely difficult to look at these documents and try to ascertain what's going on here. Much less to go in there with no pen, no pad, and just look at these documents and flag them for Mr. Nijam to be able to say, oh, these are the documents that the defense is interested in. The second we got this list,
Excuse me, Mr. Bott. May I insert an objection, Your Honor? This is a re-arguing what was heard the first time. This is not new information.
Judge, to look at these documents, once we started calling people, the very first thing our investigators realized is that these people were being called by Texas EcuSearch, advising them and warning them that the defense would be calling them, and though we've gotten different reports, some were told not to even cooperate.
I'm sorry, Your Honor. This is assuming facts not in evidence.
It's like Mr. Longo's statement, like Mr. Longo's testifying.
Objection sustained. Continue.
Anyhow, Judge, the last thing I wanted was to have another situation where an attorney who continues to inject himself into this case voluntarily is holding more press conferences. And I would submit to the court...
Objection, Your Honor.
Exhibit H.
Objection, please. Relevancy, materiality, there's none, Your Honor.
It goes to why we didn't go and inspect the documents. He opened this door.
Again, Your Honor, relevancy, materiality, there is none as to this.
What's the point you're trying to make?
Judge, this is an email from Mr. Nijam's office calling the media for everybody to come to his office to talk about how the area where Kaylee's remains were found were underwater. Okay. Now, this is the type of voluntary type of injecting himself into this case that he has done.
Your Honor, I if I might.
I realize he's very concerned,
Go ahead.
and he should be.
You're commenting on the evidence.
Yes. Thank you, Your Honor. I represent Tim Miller and Texas EcuSearch, who are being thrust into this by counsel for defendants' request. I'm simply representing a party. So the characterizations are not only dismissive, but of course, like most, incorrect. I represent a party.
There's no jury here. I'm not terribly concerned about it, other than the fact that millions of people are watching. But go ahead.
Well, Judge, I understand that issue, and for Mr. Nijab to turn around and look at me and say, "Why didn't you come to the docket?"
We're at this point. We're just griping. Let's get to the issue.
I understand, and I will go back to the issues,
Tell
Judge.
me, respond to anything else he said that you want me to not consider or just
Yes.
look at.
Well, Judge, I think the issues are clear here, where we have a situation where we should be entitled to this information. There is no privacy issue here. Mr. Nijab has turned all these documents for inspection to Mr. Conway, who's not a party to this action, who is a complete third party. He has inspected all of these documents. He has actually shown them to the state, which goes back to my original argument, where I think these documents should have been subpoenaed. We keep running into a situation where we have a case, Judge, where the defense is getting discovery a year later, stuff that will help our investigation, where everyone clearly sees we're seeking out this information. They don't want to give it to us. And I don't understand why everybody's so afraid of uncovering the truth in this case. And that's the problem here, is that there's a lack of cooperation for whatever motivations the court chooses to accept. You have a serious issue where they're trying to kill Miss Anthony, and we're trying to save her life here, and we can't do it if we're handcuffed with every twist and turn that we take. Judge, these documents are critical to the defense. We need them. The AccuSearch has waived any complete type of privacy argument that they may be clinging on to. And I would suggest this to the court as a solution. If the court is inclined to give us all of the documents, we can have them under seal and with a strict court order that they are not to be disclosed to a third party and for investigative purposes only. I don't see why this whole issue can't be resolved in that way. We will go in, copy these documents. If we'd like to inspect the originals, I will make an appropriate time for me to come to Mr. Nijab's office, and inspect any originals that there might be bad photocopies of. Nobody's name gets out. We've had this list since October 5th of 2009. Not one single person has been disclosed from this list. And I think I've represented to this court on numerous occasions when Your Honor has asked me to keep things in the strictest of confidence. Matters much more sensitive than this. And I've done so. And there hasn't been any type of leaks from the defense on these sensitive issues. And I think the court can clearly look at the defense's track record on these matters and clearly look at this as a viable solution to the problem.
Thank you. Anything else, Mr. DJ, before we conclude business here?
Just very briefly, Your Honor. As it relates to, His Honor has already done a balancing evaluation, which case law required. I've not heard any new case law that's been presented by the defense, contrary to what was presented to His Honor earlier. This does and could well contemplate harassment on behalf of the many, many thousands of people who were nowhere near where Kaylee was found. And if His Honor, you've already ruled that pretty much what Mr. Baez is seeking on behalf of the defense, and that is to allow them to come in. But they just need to come in and look. And then we had an agreement, and it's actually in the order. All they've got to do is tab anything that they deem to be relevant. We would either agree that it was relevant, or we would say if there was a disagreement, we would bring it before His Honor. His Honor would review it, determine relevancy, materiality, and then you would make a ruling. I don't know how a better system could be devised. His Honor considered all this, ruled accordingly, and I think it's readily apparent that the only reason they haven't done anything is because they've chosen not to do anything. And that door has been open for all these many months. Thank you, Your Honor.
All right. I've been handed some additional things that I've never seen before. First of all, Mr. Baez, do you want me taking these back, these photos?